in Public Practice Award in 2015 and the Young Achiever in Public Practice Award in 1998. With all of these accolades, I'm very happy to have Alex again present to us. So Alex, please, you have the floor.
Thank you very much, Celeste, for that very generous introduction. I would have been happy with our friend Alex Cabrera, and I'll be ready to go. But good afternoon as well. Cherry, Gail, President Vincent, all officers of HIMAP, our friends in the industry. I believe that that you guys will be controlling my slides. So any time that you're ready to change the page, please. So this afternoon, I'm going to talk to you about the tax implications of the not supposedly controversial, but as it turned out, it is a bit controversial now. I have 20 minutes, so please alert me if I'm nearing that. At the end, I'll also show you what the DOF wanted to turn over to the new administration. You know, the tax initiatives that they are turning over. And of course, Governor Jokno soon to assume Secretary of Finance position also has to say something about that. There's also something that the BIR is recently issued, and we got hold of that as well, so I'll share that with you also this afternoon, although it's not in my slides. So please, let's go ahead and go to my presentation. Go ahead, please, to my presentation, please, if you don't mind. I'm tired of that face, really. Thank you. So I'll show to you some salient provisions, and you'll understand why I'm showing this. It's actually important to understand this. Oops, maybe. No, sorry, I lost. Let me just go back to the screen.
Sir,
Yep.
we are showing the your slides already. Can you see?
Yeah. Sorry, I saw that.
All right, sir.
Okay. So guys, these are the relevant provisions, and I'll show something interesting as well after the comparison of these two. The PEZA law already referred that eco zones should be operating, or the business establishment should be operating within the eco zones. And really, when you read 309, even as it mentioned exclusively, it also mentioned this very important second part, which I quote here: any project or activity conducted or performed outside the zone shall not be entitled to incentives. Now, before I go deeper there, let me show you this provision that this telecommuting law. Next page, please. Then we'll go back to this page. So the Telecommuting Act, well, gives the employees, or actually encourages or even requires employers to give their employees an option to work from home. And the basis being used in the Telecommuting Act is that employees is a substantial and very important economic force, and that the government should be concerned about the employees' welfare. Now, if you will go back to the earlier slide comparing the PEZA and the CREATE Act, please. So this is the Telecommuting Act, and if you go back to the earlier slide, I'll tell you that if you compare that with CREATE, it would appear that the Telecommuting Act is the general law and the CREATE is the special law. And special laws provide an exception to general laws. That's one of the legal maxims that can be used. Except this part. When the telecommuting law was issued, the PEZA law was in existence. In other words, when the law meant all employers, it meant all employers. It meant registered business enterprises and non-registered business enterprises. It is making this available to all. And if there are conditions that must be imposed, one thing is quite sure. It must be available to all. Otherwise, you will have a national policy that cares about the employees of non-registered business enterprises, but disregards the welfare of the employees of registered enterprises. That could not have been the intention of the law. So when the PEZA, for instance, came up with this policy of allocating the 70-30 export and domestic and applying that to the labor force of the PEZA registered enterprises, it is really quite reasonable. At least to that extent, it is quite reasonable. In fact, as I mentioned in my other presentations, they deserve more than that. But it is quite reasonable because when there is a law, you should not interpret it, if you can, you should not interpret it to be in conflict with other laws. As long as you can, you should harmonize it. And the only way to harmonize it is to apply the Telecommuting Act to everyone and for PEZA registered enterprises to be subject to certain conditions. In other words, when the CREATE law was passed, I would go on to say that it cannot be interpreted to totally disregard the Telecommuting Act. Because if the Telecommuting Act could be disregarded, then it should have been disregarded as early as when it was passed. Earlier, when the PEZA law was already in existence. Besides, we already have this observation that even this can be interpreted. There are, in fact, Supreme Court decisions not involving the CREATE law, involving religious organizations and educational institutions, that the way that you read directly and exclusively is principally. No, but let's have more of that maybe later, because we only have 20 minutes. Okay, next page, please. So I don't agree with PEZA that the telecommuting law argument is dead. It's not dead. Work from home issues. Next, please. Okay, let's go to. So actually, what I wanted to say here is that the Deputy Commissioner for Operations actually issued a BIR memorandum to all regional directors of the BIR. I'm looking at it now. We only just got hold of a copy of this. It referred to the 9010, which expired March 31. And then thereafter, it says everybody should be reporting to the office 100%. It mentioned about the authority given by the PEZA, allowing a 30% work from home. And it said that the FIRB did not approve this 70-30. And therefore, it is directing the BIR to conduct ocular inspection and regularly monitor the activities of these RBEs through mission orders. Now, before you get all agitated, let's understand. This is a memorandum order. It's not a revenue regulation. So it's like the BIR telling their people how they should operate. And of course, there are many instances that the BIR would do what it wants to do. Although the BR is subject to correction, and later on, I believe that this can still be corrected, especially if we raise these issues that I am about to discuss. Next slide, please. First thing in point, next slide, please. Case in point, for instance, in the create IRR, the allowance that should be given to registered enterprises should be until the pandemic has ended or has ceased to exist. So during level 1, during the still ongoing booster shots and still requirements of everybody wear a face mask. In fact, in the board exams, there's even a rule for the students to wear face shields. Those instances show that the pandemic or the threat has not yet ended, or that the threat has ceased to exist. In other words, the temporary measures should have been still effective, and there's still merit to continuing the extension. Of course, the FIRB is headed by the Secretary of Finance, and the Secretary of Finance feels otherwise. It's still not the end of the world. Next slide, please. With painted that. Next slide, please. Next time I control my slides if I'm allowed.
We are on, yeah, it's on next slide already, sir.
All right. Oh, okay, so this is the slide on the movement of, is this the next slide? Wait, let me just check. Yes, it is. Okay. Yeah, this is the next slide. So this is actually still an existing PESA memorandum circular. And what it shows here is that when you bring out equipment, you're supposed to post a bond. And when there was a work from home, that is when the bond became necessary. But say that you're not working from home, you're working on site, and you're bringing your computer at home because you want to sleep with your computer, or you want to watch Netflix with it. You bring it back to the zone the following day. See, those are the instances, but before they don't even care, because you can do that, and because you're allowed to bring that out, because you have expectations of bringing that back. But the worst that they can do really is to ask for a surety bond, to be sure that when you bring that out and you return it, sometimes it's 6 months, and then they can extend it, but they cannot collect duties every time that the equipment goes out. You know, there's just no legal basis for that. Next slide, please. O, yan na yung 20 minutes ko kinakain ng palit ng slides. Next slide, yeah. Okay. So I discussed about these mission orders. Next slide, please. Are these mission orders correct? Do they have legal basis? Next slide, please. Yeah, so those are the authorized activities in the mission order. So sorry, can we go to the next slide? I apologize for this. I don't have command of my presentation.
Do you want to show it yourself, Alex?
Yeah.
Can we do that, team? That Alex will show his slides? give
You have
him.
the permission now, Attorney Alex. Thank you.
Happily. Yeah. So we did this. We did this. So we're at the mission orders, and whether the BR can whether the FIRB can do this. And you can see here the power of the FIRB under the create law shall check and verify as necessary the compliance of business enterprises, and it shall endorse registered business enterprises. I mean, it can endorse the cancellation of the registered business enterprises. But this is, I wanted to show you this. Section 3 of the FIRB or Rule 13 of the FIRR. The FIRB oversight functions over registered business enterprises. And I want you to understand this because to me, this is the provision that can really question the mission orders coming from the BAR. The FIRB shall monitor and review compliance of registered business enterprises, right? But it says through the IPAs, not the BAR. And the FIRB, upon prior notification to the registered enterprise, in coordination with the IPA, having jurisdiction, shall have the power to verify the documents by conducting an inspection. It's not a spot check. It's not a surprise visit. It's prior notification, and it's not the BAR. It should be through the IPAs. So these mission orders, are they valid? Look at the authority of the BAR commissioner under the tax code. It may place business operations of any person, natural or juridical, under observation or surveillance if there is reason to believe that such person is not declaring his correct income, sales, or receipts for internal revenue tax purposes. When is a surveillance going to be warranted? When there's reason to believe that the entity is not declaring their correct income. It's a question of declaration or under declaration. Because if you declare your income and there's something wrong with how you compute your tax, the BIR is not deprived of the opportunity to do that computation later on after the filing. And do I have basis in saying that? Wait, I think here, the power of the commissioner in ascertaining the correctness of any return, or in making a return when none has been made, or in determining the liability of the person for taxes, etc. The commissioner is authorized to examine any book, paper record. What you don't realize here is that the commissioner is authorized to examine the books, paper records, I mean, these details in the conduct of an examination when it is already ascertained the correctness of a return. In other words, when the BIR comes to your office, show me your records, show me the records of your employees, show me how much taxes have you paid. They are not authorized to do so because they need a letter of authority, and the basis of their examination must be the return that you filed. See? And insofar as suspension of business operations are concerned, you can only be suspended in your operations, not because you're not working in the zone or everybody's working from home. Your operations cannot be suspended because under Section 115, it can only be suspended if you fail to issue receipts, fail to file your return, you understate more than 30%, which is equivalent to fraud, and then you're not registered. These are the only grounds for suspension of business operation. And what do you think of these laws? What do you think of these requirements in the law? Beautiful words? Of course not. We need to apply this. And kahit na may ginaganahan dyan na mag-mission order, we need to be able to learn how to push back. And I think after this presentation, I'll talk to Commissioner Plaza and show to her that this is the basis of their authority. They can only implement by themselves, and it's not the BR implementing the incentives, it's the IPAs. And the IPA should be monitoring. Maybe they should be coordinating with the BIR, but it should not be the BIR doing it. So hindi pwede yung pananakot, threats, and compliance, etc. The imposition of penalties, I just wanted to emphasize that FIRB may cancel, suspend, or withdraw, but only after due process. So when the BIR comes to your office and says, tomorrow we will close your office unless, the BIR cannot do that. It is the FIRB that can cancel or suspend the operations of the IPA or the enjoyment of incentives after due process. And what does due process mean? Why are you not making your employees work 100% in the zone? Then you reply, why? That's due process. It cannot be, how many are your employees? 100? How many is here? 30? Violation, your incentives are canceled. That's not due process, ladies and gentlemen. Due process is required, which means notice and opportunity for the registered enterprise to explain. Kasi ang hirap po talaga ng mission order. Gusto niyo po ng example kung bakit po siya mahirap gawin, even for the BIR? There's a lot of issues that can be raised. Some BPOs are on a full cost, full absorption basis, and they're able to charge all their time, and they're able to put a margin on all of their expenses. So arguably, everything there is direct cost. But there are also some BPOs or some registered enterprises that really have direct cost, and some of them have administrative. And how does the FIRB define registered activity so far? Only in relation to direct cost. So the rest of the cast, which is not really performing direct services to clients, they don't need to work in the zone. If you will follow the menu that the FIRB is using. And if you follow the menu that the Telecommuting Act is trying to give, then only 70% is required to report within the zone. And then, is that on a daily basis? Is that on a weekly basis? And you will see that this is a function of the revenue that is also produced. So it says indeed operations within the zone, but what do you mean by operations? Is it revenue? Is it people there, etc.? So hindi siya straightforward yung mission order ng BIR. That's the only thing that I'm saying. And this is more observance of due process. Look, and this is the great bias here. And I think this is what happened with PEZA, with all due respect to them, because PEZA really is such a great investment enabler, and they have great relationships with registered enterprises. But look at what they did to these IPAs. Pinareho lang po sa RBEs. No penalty shall be imposed upon IPAs or GAs, RBEs or REs, or any responsible officer for failure to comply with the requirements of the rules. So even IPAs can be punished if they don't comply with the rules. And I would suppose that probably the PESA's attention was called, and this is the position of the FIRB, and they were probably required to reply in writing. But I'm just guessing here, because they just categorize the IPAs along with the registered business enterprises. But no penalty unless you're informed of the violation, and then due process must be observed. Okay, the last part of my slide shows you um, Pamana Especial of the Department of Finance to the next administration. And I think what I'm trying to show you here is that there's not much emphasis on what they're doing with registered enterprises. What they're trying to say here, okay, personal income tax exemption, I don't think that will push through because you're going to hurt the individuals. And that's bad politics for the government. Expansion of the VAT base, but reduction of VAT, I doubt. Repeal of the input VAT on capital goods, they can easily do that. Excise tax on single-use plastics, that may increase the price of the goods, in two ways. If they pass on the tax to you or if they change the way that they pack their goods. But this is necessary for the environment. On gaming, the Real Property Valuation and Assessment Reform Act, this will, supported by businesses, right? But I tell you, this is going to increase your taxes, real estate taxes, because even your real property taxes will be based on evaluation by appraisers. And you know how appraisers, professional appraisers appraise, mataas. And the appraised amounts of the properties, the market values, replacement values that they put there, you can't even sell your property at those prices. Anyway, this is one of those pending, one value for everything, for capital gains tax, for income tax, for documentary stamp tax, for real property tax. This is syntax, cryptocurrencies, good luck, transfer pricing, easy, carbon tax. And so what you've noticed here is that there is no initiative that's saying that we're going to clamp down on registered enterprises. And the communication coming from the Secretary of Finance is that he agrees with some of them he doesn't agree. And he's going to lock down on, focus on tax administration. But of course, we know Governor Jokno could be quite objective and reasonable. And of course, Fred Pascual of President of MAP, listens and uses his independent analysis when he tries to resolve certain issues. I mentioned these two personalities because they are the two personalities that really matter in the FIRB. They are co-chairs. Right now, the DTI, apologies, the DTI secretary is not too relevant in the FIRB because it's the Secretary of Finance really pushing his weight. But so I have faith in Mr. Fred Pascual and the objectivity of the incoming Secretary of Finance. I hope to make headway when we have discussions with them, to explain to them the macro and the micro, the jungle and the trees of all the issues confronting registered business enterprises. I'll stop there. Thank you very much for listening.
Thank you, Alex. That's really encouraging. It seems like we are not in such dire straits. There's a lot of options or routes that we can take only if the parties concerned will recognize, what you have discussed. And I'm sure there's a lot of questions about your presentation. We will go to Q&A later after the DOLE presentation, but really music to my ears what I heard from you, Alex, and I'm sure that many of these we will try to explore, immediately, so that we get some relief, with the problems that we are now encountering. So let's pause for now on the tax matters and go to the other side of the same issue on work from home. We have after the return to office order of the FIRB, but even before that, when we were already massively implementing work from home, there are many questions that have come up in terms of, how employees should be compensated. Are there tax implications in terms of work from home? And many other questions that have been raised not only by registered business enterprises, but employees themselves. And we hope to get some clarity from our next speaker from the DOLE. She is Polly Andrenette Grace Ong, but she said we can call her Polly for short. She is currently the Labor and Employment Officer 2 of the Department of Labor and Employment Bureau of Working Conditions. She has been with the DOLE since 2019, and therefore just before the pandemic. So I guess she's more familiar with our situation because COVID followed right after her joining DOLE. So Polly, if you can start your presentation, please. Thank you.
Yes, so good afternoon, everyone. So I'm from the Policy and Program Development Division of the Bureau of Working Conditions, and I was a part of the technical working group that formulated the implementing rules and regulations of the Telecommuting Act. So what I'm going to discuss with you today is telecommuting as a general concept and the matters that are frequently asked in terms of implementing this work arrangement. So just a brief overview, the Telecommuting Act was enacted on December 20, 2018 and took effect on January 2019. Ooh, sorry, someone said that they can't hear me. So let me continue po. So the implementing rules and regulations of Telecommuting Act was issued by the Department of Labor and Employment on March 26, 2019. Okay, audio not clear.
We can hear you, Polly, but I think the barking of the dog is louder.
And also your slide is not moving, Miss Polly.
Yeah. I requested Miss Kathy to actually share my slides.
Kathy?
Is your slide also being controlled by HIMAP, Polly?
Yes po, Miss Kathy will control my slides po.
Okay, please.
So going back, but the presentation is actually not on full screen. But anyway, going back to my presentation, the implementing rules and regulations of the Telecommuting Act was issued on March 26, 2019 and was published in Manila Times on April 24, 2019. And just a disclaimer, while the Department of Labor and Employment promotes the adoption of telecommuting work arrangement in the private sector, such as work from home, we do also recognize the mandate of other government agencies exercising special jurisdiction over the economic zones. And as clarified by the Department of Finance, business establishments are at the liberty to continue work from home or telecommuting, but it cannot enjoy tax breaks if registered with investment promotion agencies that requires them to have their employees work on site. So next, please. Next slide, please, on the definition of telecommuting.
And kindly put the presentation on presentation mode, please.
It's already, it shows on presentation mode already.
No.
Oh,
Is it the
edited.
one that was
Cherino.
shared?
But
There
it's
you go.
on our screen, it's already on presentation mode.
From
Makabalik
our
that Cherry.
screen, not yet.
Yeah,
So
on our screen.
can we have Polly control her
Yes.
slides?
The previous one, please. Slide 2. Second slide. Yeah, there. So if we are to dissect the definition of telecommuting as provided for in the Telecommuting Act and its implementing rules and regulations. So there are two things that we must take note here. First is what is alternative workplace? And second, the use of telecommunication and or computer technology in carrying or performing the work from an alternative workplace. So what is alternative workplace? So as defined in the implementing rules and regulations, alternative workplace refers to a location other than the regular workplace. So this could be a site of the company that is nearer to the residence of the employee or the residence of the employee itself, or any place that may be considered as appropriate alternative workplace as provided for in the company's telecommuting policy or program. And who determines these appropriate alternative workplaces? It is the employer, but again, this must be provided for in the company's telecommuting program. So, for example, if in the telecommuting program of the company, it provides that other sites lang nila ang considered as alternative workplace, then for those who will telecommute, this is valid because telecommuting is not limited to work from home. So pag telecommuting, hindi automatic work from home. So that's it. So what I'd like to highlight here is that the adoption of telecommuting work arrangement is the company's prerogative, whether to offer it or not. Kasi it is voluntary. So the employer may not be forced to offer work from home should the employee demand, but should they agree to adopt telecommuting as a work arrangement or work from home, the benefits of the employee should not be less than the minimum labor standard set by law. And lastly, since ang binabago lang naman in a telecommuting work arrangement is the place where the work is to be performed or carried out, the telecommuting employees should be afforded fair treatment. And what do we mean by fair treatment? As provided for in the IRR, it is same treatment as that of comparable employees working at the employer's premises or the regular workplace. In fact, the law also mandates employer to ensure that measures are taken that the telecommuting employees will not be isolated from their working community. So should the company offer telecommuting as a program and there are employees that are interested or willing to avail this program. For the effective implementation of this work arrangement, the company must prepare or must have a telecommuting program. And as defined in the IRR, telecommuting program is a set of guidelines and rules governing the implementation of a telecommuting work arrangement. So as I have mentioned, at the minimum, the terms and conditions of the program must not be less than the minimum labor standards set by law, such as that on overtime pay, less day, the regular working hours. But what are the other matters that must be included in the program? First, we have the duration of the program. Mula kailan ba i-implement itong program and until when? So second, what are the rights, duties, and responsibilities of the employee? Ano yung mga right na pwedeng i-invoke ng employee? And what are the duties and responsibilities that the employee must perform and observe? And also, we have the eligibility. What is the applicable code of conduct? Or how will the telecommuting employees be evaluated? How would this affect their compensation? Meron bang additional allowances? Paano yung sa dispute settlement? How about termination or change of work arrangement? But for purposes of today's discussion, I'll just limited my discussion sa mga naka-enumerate here in my screen. So first, let's go to eligibility. So in eligibility, the telecommuting program must identify what are the positions that may be carried out remotely. So we are fully aware naman that not all positions or trabaho is telecommutable. So the program must also set forth what are the conditions or requirements that the employee must satisfy for him or her to be eligible. So this may also include the appropriate workspace or the speed of internet that would be required by the company. Then next is alternative the appropriate alternative workplace. So as I have mentioned earlier, this is determined by the company, but this may be the other side of the company identified co-working spaces or the residence itself of the employee. So kapag sinabi ng employer na other sites lang, hindi pwede sa bahay, coffee shop, or beach. But if hindi naman nilimit ni company na ang alternative workplaces is other sites lang, then pwede sa coffee shop or beach like what I've observed sa mga travels ko. Then next is on the use and equipment. So the dictionary definition of equipment is the set of articles or physical resources serving to equip a person. So an example of this is laptop, mobile phones, or webcams for Zoom meetings. So the program should also identify what are the equipment that will be provided by the company. And if the company will provide one, what is expected from the employee in terms of handling and care of this equipment. But if none will be provided, may the employee reimburse from the employer the cost that she will incur in purchasing the equipment required in telecommuting, or will the company subsidize a portion of it? Then on compensation, what's frequently asked here is allowance. Since in telecommuting, some say that there will be an increase in electricity consumption and they have to avail for a higher internet speed. So they'd ask, is the employer mandated to give their employees electric allowance, internet allowance? Hindi po automatic. Again, this must be provided for in the telecommuting program. Then on occupational safety and health, so the law requires that in the telecommuting program, there must also be a specific occupational safety and health program specific for telecommuting employees. So this should include, among others, a program for medical surveillance for early detection and management of occupational and work-related illnesses and disease, or promotion of healthy lifestyle to prevent work fatigue, especially if they'll not be using ergonomically designed table and chair, and also what are the mental health services that are available. Then on termination or change of work arrangement, so one may ask, may the employer or the employee terminate their telecommuting work arrangement? Let's say the employer decides na ayaw na nilang i-allow yung employees nila to work from home or to telecommute. The answer here is definitely yes, but this must be done in accordance with the procedure that will be laid down in the telecommuting program. So this may include the notice requirement. In what form should the notice be given sa employee or sa employer if they will terminate the telecommuting work arrangement? So paano if the employer refuses to return on site, or the employer refuses to allow the employee to return on site kasi let's say there's no enough workstation for these telecommuting employee. So this should all be provided for or stated in a telecommuting program. And for the employer, as long as the return to work on-site order is communicated properly or is compelled due to some governmental directives, they may validly do so, and the refusal of the employee is unjustified. The bottom line here lang naman in termination or change of work arrangement is that notice must be given in accordance with the procedure laid out in the telecommuting program. Hindi yung night before, inform mo si worker, you have to go on site. So again, just give the notice, and the notice must be given within a reasonable period of time before the effective termination of the telecommuting work arrangement. Then, in terms of dispute settlement, as provided for in the Telecommuting Act and its IRR, it is the parties to a telecommuting work arrangement that shall be primarily responsible for the administration of the program. And in case of any differences in the interpretation of the program, this shall be treated as grievance mechanism. As grievance under the company's grievance mechanism. But if in the absence of this grievance mechanism, or if this is inadequate, the employee may request for an RFA or request for assistance under those single entry approach program. So next slide po, on reporting. So one of the registration question is that are those who were are those who already do those who already submitted their report to PEZA still required to submit a report to DOLE on their implementation or adoption of telecommuting work arrangement? The answer here is yes, because as provided in the IRR of the telecommuting, the employer was actually specifically required to submit a report. And if the company has a branch or operational unit outside the region of its principal office, each of these must separately submit their report to the nearest DOLE office having jurisdiction over that office. So the report may be submitted in two ways: by accomplishing RKS Form 5 of 2020 as attached in DOLE Labor Advisory number 17-E, or through the DOLE Establishment Report System. So the other option is online. So, and the next slide po on labor inspection. So on labor inspection, so if an inspector will visit your premises, there are two things that we must ask them para masiguro natin that the one you are speaking with is really a labor inspector of the DOLE. First is the authority to inspect, because prior to the inspection, the regional director of said labor inspector will issue an authority to inspect, specifying therein the name of the company and of course the DOLE ID. So para masiguro natin that the labor inspector indicated in the authority to inspect is the same person who appeared in front of you. And what are the documents you have to prepare sa pag merong inspection? So employment records, policies, programs, and reports, and roster of workers. So yung submission natin ng report on the adoption of telecommuting work arrangement, dyan siya papasok. Because in the absence of these report, the inspector may note it as a non-compliance and still require you to submit the report para makorek natin itong non-compliance natin on the report requirement of the IRR of Telecommuting Act. So, next po. So, here ends my presentation, and thank you for listening, and good afternoon po.
Thank you, Polly. That's very detailed. Personally, I think it's the first time that there's this very detailed presentation on telecommuting. I just note that during the 2 years of the pandemic, our member companies, the RBEs, have sort of already followed the terms and conditions of Telecommuting Act. I think what is now in the minds of our members is that is the Telecommuting Act really the superior law compared to Section 309 of CREATE? I guess that's going to be a hot conversation in the later panel discussion. So after those two presentations, we are now ready for the panel discussion, and we will be joined by two other resource persons. We have Attorney Mike Montero, who is currently the APAC Regional General Counsel and Vice President for Government and Regulatory Affairs, a member of the Global Employment Team, Data Protection Officer, member of the Board of Directors and Corporate Secretary since 2006 up to the present of Concentrix. Quite long, now there's more. Management of the company's APAC, legal and employment, compliance and government, and corporate affairs functions, including acting as the company's general counsel and the corporate secretary, management of the legal group of the company, and sitting as a director in the company's boards, and performs functions as the chief privacy officer and also as the company's government and corporate affairs lead. And why did I go through all that? So that we will understand why we always get Attorney Mike to speak in this forum. So Attorney Mike, we will listen to you. You have 3 minutes to have an introductory statement, preliminary statement, and then we'll ask the same for the next resource person. Go ahead, please.
Thank you, Ma'am Celeste. And thank you for thank you to HIMAP for having me here. No? Maybe I'll just touch on the stuff that both Alex and Polly have already discussed, no? And really very briefly, which is a difficult task for me as Ma'am Celeste would know. I guess maybe one thing that we always say, no, as a premise for all these arguments about still having to retain our incentives insofar as work at home is concerned is that the very essence of getting the incentives is that we export, right? I mean, since time immemorial, we've really known the premise for the grant of the incentives as because of the fact that we basically deliver a couple of things, no? Foreign currency revenues as well as employment, and we continue to do that. No? So that's probably one of the things that we need to stress a little bit more as we progress or as a transition into the new administration and we revisit all the conversations that we've had with them. Having said that, I know that also part of the reason why I was asked to be part of the panel is that I think you've read that among other companies now that have made declarations as well, that Concentrix has taken a position with respect to retaining, in a manner of speaking, no, the split that we were observing for most part of the pandemic, and not to disturb that too much. No? I will steal a line from Jack Madrid, who is IBPAP's president, when we last were together in a forum that I cannot recall anymore. No? I guess maybe the overarching message that will come for any company that has adopted any sort of moving forward arrangement is that no one size actually fits all, and each company has to make a determination of what their priorities are, and maybe taking into account all those priorities, make a decision on that basis. I guess maybe the only thing that we really want to stress is that it's really not a situation where we're giving up our tax incentives. Although it could be semantics or it's really just a way of conveying the message. But truth be told, when you think about all the considerations, you have clients, you have your employees, and then obviously you have your bottom line to take into account. And the loss or the decrease in the incentives that we're getting is going to hit the last among the three. No? But nevertheless, I think what we need to really understand is that as we continue all our conversations, we need to stress on the fact that it should not be a situation where we're actually weighing one priority over the other. Because who would want to lose the clients and therefore reduce the tax base? No? Who would want to lose employees and have them migrate to other industries, right? So we don't want to be, and as we have already been, no? Be placed in a situation where we have to choose between one or the other. Because we again firmly believe that there's really a workable solution to all of this. No? But even then, in the instances that I've had the opportunity to speak, I always say that, and again, just to maybe emphasize the period that we're in, which is as we engage with the new administration and as we refresh our arguments, so if you could call them that, we need to always buttress or maybe support them, no, with the empirical data and information. So if we say that even if we're not losing business but we're unable to grow, what does that actually mean? No? So if we say that people are not wanting to stay within the industry, how many are we actually talking about? No? Because these are the ammunitions and the tools that will enable Celeste and everybody else that's at the forefront of all these discussions to again make sure that there's a clearer understanding of our situation. Just very quickly on the BIR audits that anyway Alex already touched upon. No? So there's been a lot of submissions that have been made by PEZA registered companies to PEZA. No? So our well, at least my personal counsel to my company is that as much as we can, let's not create new submissions anymore, and let's make the BIR understand that again, and Alex touched upon this. No? IPA is really the primary. Our IPA, which is the PEZA, is the primary agency that has jurisdiction over us. And then just maybe lastly, I just want to make mention that well, I guess maybe now turning to what Polly touched upon. So one is that we need to realize that one of the things that had been, at least for our company, that we made sure we really were very careful about in terms of allowing folks to stay in a work at home arrangement, is that we still have to contend, and I guess maybe Polly could also clarify this as well. No? There was an issuance that was dated 2020 of January. I think that the circumstance under which it was issued was that because I think we were suffering through the eruption of Taal volcano. No? And one of the salient provision, or perhaps maybe the most salient provision, is that we cannot force people to go back to work if they feel that there's an imminent danger that's born out of either a natural or a man-made calamity. So I guess maybe part and parcel of that whole process that Polly outlined of being able to recall people back to work is really the sensitivity around understanding where we are at still, no, at the moment with respect to the pandemic. No? Because again, maybe the additional complexity to that is that we still have the MARPs, no? The most at-risk persons, and would we now therefore have, or should we therefore exercise greater flexibility in allowing them to come back? No? And also, I guess maybe one other conversation that typically arises from a discussion on work at home is cybersecurity. No, so I'm not going to delve into that too much, but just to say that AI monitoring on those that are at work at home is something that has been initiated already as a conversation with the NPC. And if any companies here are also into that and have already introduced that or are wanting to introduce that in their work at home arrangements, then please make yourself known so that you could be part of the group that could have this. Sorry, just one last very quick point, Celeste. I just want to make sure that this point is made clear. Just a bit of history, no? This provision, the provision that Alex touched upon, which is Section 309, which is now causing all the pain points, all the body aches that we've been having over the past several months. No? It was not something that was inserted without the people that were involved in the discussion not knowing about it. But when we brought it up as an issue, it was represented to us that don't worry because that provision is really meant for the POGOs. No? And my point being is that we have to really just be diligent and vigilant. No? That again, as we are have all this information available to us, no, we always make it available as well in turn to the group, so that we have the greater ability to move as one, so that again we are not placed in a situation where we just remedy damages that would have been created by things such as this. Thank you, Celeste. As usual, I talk too long.
Thank you, Attorney Mike. I guess you brought up early pains and hurt when we saw the final version of Create, and we were trying to get a correction to Section 309 via the IRR. But that's water under the bridge. We're now in this situation. There's a number of questions that I wanted to ask to you that you have covered in your discussion. And just to put into context, I was going to ask you if you giving up the tax perks are substantial and may affect the profitability of your Philippine operations. I'm sure it would be if you really did give up the tax perks, and that there really is a deeper context to that statement, and you have explained it well. So therefore, I guess we should not hear questions anymore that are there business enterprises who have really given up their tax perks. So Attorney Mike has explained the context behind that statement. So if you are weighing between profitability and significant attrition, then the company will have to make a determination what is important to them. And we have always said that it is more important to us to retain our employees because, getting talent, even from the whole country, is always the biggest challenge for a BPO player. So I guess we have all of the three panelists now. I understand that the other person we have invited is not able to join. So I'd like to invite both Alex and Polly to answer questions that our audience might have. But maybe we can start by saying that we actually got more than 50 questions already before the activity even started, and many of them have been covered by our presenters. Maybe just to make this a little provocative now, and I'd speak with both of our lawyers here. So Attorney Mike, Alex mentioned a number of items like the MC of the BIR that seems to be like internal to them, and there are provisions of law that we can look into and push back in terms of what both the BIR and the Bureau of Customs are doing. Do you agree? Do you think that these are things that we should have looked at before and have not done so, or have we looked at them but we thought that FIRB statement is really the top hierarchy in the consideration of all these things?
No, I agree 100% with Alex, of course. No, Alex is really a very respected, I guess maybe, and a top-notch lawyer at that. No, and he always makes sure to take a look at all the details and the angles of any issue. No, I guess maybe the reason, perhaps, no, that I will say that we did not take a position that was really anchored on the legal nuances is that because and this, Celeste, the way that we always approach this is that we try to premise our conversations from the angle of making the government stakeholders realize that more than anything, right, this is really for the business community or the industry, and inevitably, if you're wanting to preserve all the gains that we've had through the years, no? And Jack would always talk about that while we're still growing, this is the first time in many years that our growth is really lower than what has been achieved from a global perspective. No? So I think while we probably had to a certain extent, to a very limited extent compared to how Alex presented it, no, had already viewed the issue as attracting some legal arguments that could be put forward. We dedicated our time for the most part to trying to make government understand that what is that this again just to reiterate, Celeste, no, this was not the conversation that we had several months back, no, when 309 was there, and 309 is really the be all and end all of all these issues, no.
Right.
There were, unfortunately, they were verbal representations, no? Because if they were otherwise, then we would have really pushed harder, no, in making sure that it was not going to make it into the enrolled bill, no. But
Right.
nevertheless, we obviously took took the lead of PESA, no, in wanting to again put our position forward. But I guess maybe the crucial thing to consider is that, and Alex knows this, no, because in the conversations that have been had within the government entities that have something to say about this, they're now transitioning to asking the question of whether there's legal basis. And I think that's precisely where Alex is coming from, no, in saying that if you really want a discussion on whether there's legal basis, then this is our legal basis. But just one point on that, Celeste, no, I don't really buy, and I'm sorry to have to say it that way, no, but I'm not a fan of that statement that there's no legal basis, therefore we cannot accommodate what you're requesting, no.
Mm-hmm.
In the legal basis that they're citing is the CREATE law. The CREATE law has been in place since July 1 of 2021. why then were we able to enjoy the 90-10 from July 1, 2021 until March 31, 2022? And the plain and simple answer to that is that because the FIRB, the DOF, or the executive branch of government felt that more than clinging to that Section 309, there were larger things at stake. The BPO industry was the one of those that really made sure that we survived the pandemic. No? So it's not the legal basis because it's been there for over 9 months already, no? Before they finally said that we have to shut it down. So, but again, I totally agree with Alex, and I guess maybe if the industry feels that it should now be, we should now reach that stage where we have to make this a legal, discussion, then all for it.
Yes. Thank you, Attorney Mike. And even if I am not a lawyer, I totally agree also with Alex. As I said earlier, I'm excited about the insights that he shared, and we really look forward to deeper discussion so that we can take the route that we really need to take following the guidance of Alex. So I have a question here following your presentation, Alex. So you said that there's this different routes that we can take. So what do you think is the best now that the industry should take in order to more quickly and effectively address our problems and the challenges that we are going through because of this work from home or hybrid work model that's not being recognized by the FIRB? Among the things that you have mentioned, which do you think has a greater success in terms of quickness and being effective?
Yes. Well, you may be surprised that I think the best angle that will bring success, and I'm saying with the new administration, is the angle on discrimination of employees of registered business enterprises. That for me is a political angle because they are not only governing and protecting the welfare of employees who are outside economic zones, they're also supposed to protect the welfare of employees within the special economic zones. In fact, if you will look at, I'm fond of looking at the worst case and the best case. Of course, the best case is we have all that. But even assuming under the current administration, without help of the new government, the worst case really that can happen, and I'm just being very objective here, is 2 books of accounts. And the 2 books of accounts is so that you can monitor the activities being conducted outside of the zone. If you look at 309, it also has the phrase, any project conducted or performed outside the zone shall not be entitled to the incentives. In other words, if these are not entitled to incentives, and I'm not saying that this is correct or this is the only way to interpret this, but on the worst case that this is not entitled to incentives, then only that portion conducted outside the zone will not be entitled to incentives. In other words, if, for instance, many of you are doing the 70-30, then you have 2 books of accounts to compute the regular corporate income tax, doing the proper allocation of expenses to that activity conducted outside of the zone, and then the rest of the activities conducted within the zone will continue to enjoy incentives. What's the legal basis? This horrible Section 309 itself provided that penalty. So whoever tells you that if you have business being conducted outside the zone, you violate it and therefore you're not entitled to any incentive, that is just simply wrong. Because 309 itself says that only that which is conducted outside will not be entitled to incentive. So, but I really like the angle of discrimination of employees because this government is going to be, do we have time to discuss politics a bit? If you look at the government of President Duterte, there's something that he did that's very good with the masses. No, not the killings, etc. I mean, that's the worst that he did. And people are saying, well, at least that benefits us because, this the drug problems is trying to address that. But there are many things, and not the least of which are those that impact directly the individuals. The free tuition of high school, whatever level in public schools, the 10-year validity of the licenses, etc. I'm not going to enumerate everything. Of course, the ayudas during the pandemic also helped a lot. This impact the individuals directly. And the government knows this. And much of the support to the present government is because there are individuals directly impacted by this legislation. And some of the individuals, maybe they don't care about taxes being leaking or being corrupted, or, because they don't pay taxes. And they'll say it's not our money. But those that directly impact, individuals in general will have a political impact. So that's the reason why I'm saying that I like the discrimination angle. I like to tell them that you are discriminating not really the PESA registered companies. We also have that angle, but it doesn't seem to sell very well. We need to sell the discrimination on the employees. And all employers have that right. Our presenter indeed said that Miss Polly Ong indeed said that it is optional. It is voluntary. Agree. No problems on the voluntary. But everyone gets this right. Everyone gets this right. And it's up to you to refuse this right. So if they're saying that if you're a registered business enterprise, you don't get this right, that is wrong. You get that right. And if you look at the provisions of the law, it is giving that because of present day realities, advancement in technology, etc. That's the very thing that registered enterprises have. The technology, that is what registered business enterprises have. And to discriminate their employees, to not give them this right, is certainly not within the purview of the Telecommuting Act. So that's really the point. I have no disagreement with the voluntariness of it, because you cannot compel work from home. How can people manufacture if they're working from home?
Right.
You have to be in the plant. Of course, it cannot be mandated.
Yeah, it's not discrimination. Yeah.
Yeah. Everybody gets this right. Okay.
Okay.
Hope I
Thank
answered the
you.
question.
Yes, you did. My mind, however, is sort of debating. You argue with the FIRB that there's discrimination. Who will make a determination? Because they push back also. We have a lot of justifications as to why a hybrid work model is necessary, and the result that it has been denied. So if we go back to something that is more familiar and probably something that our members are more inclined to do, and this is about registering with BOI to be able to get a work from home permission. Is this a good route? Is cancellation of registration with PESA going to be beneficial? And moving to a BOI registration, is it something that more quickly understood because there are sort of guidelines already that can cover that, Alex?
Um, yes, Celeste, to make the bluff and to be able to call the bluff, if I can state it in brief. And the reason why I say that is, as I discussed in an earlier forum, the section 296 of the second paragraph, I believe, which mentions about the right of registered PESA or registered business enterprises, the existing registered business enterprises, to register under create, to register with the incentives under create. So this provision, this 296, is actually referring to new enterprises, new projects, and existing projects. So they cannot skip reading the existing projects, okay? These are the existing projects. And they say that existing projects can register for incentives under create, which means you can transfer registration. There's no sense registering with PESA because you're already in PESA, right? So when they
Right.
say register under create, that can only mean registering with another IPA. Sorry, sa akin malakas eh. Can you mute
Yeah.
if you're not speaking, please?
Can you put yourselves on mute if you are not part of the panel, please? Okay.
Yeah, police. And I'm saying be able to call the bluff because, and the only reason why I'm saying bluff is again, we can use the argument of the discrimination or to the benefit of the individual, and then argue that really the value of PESA is the countryside development. Because if everybody transfers to the BOI, that's the bluff, right? I mentioned this in a more intimate setting, you know, because not everyone may be looking at transferring to PESA, but it is actually a legislation that transferring from PESA, but it is actually a legislation that we can put forward. The renaming of PESA to a simply an industrial zone, industrial export zone that can have the benefits being given to BOI. So that can be part of legislation. But the only reason why I call it a bluff now is if everybody transfers to BOI, PESA will be dead. What happens to the countryside development? What happens to this foreign investors that really trust PESA and likes the environment of a secured zone and likes the environment of you know being taken care of by the IPA, the speedy processing of the visa and the one-stop shop nature that can be made available in PESA. What happens to all that and what happens to the ease of doing business? So the value of the PESA will be more than the work from home, you know, but the countryside development and the ease of doing business that it carries along with it. I mentioned the discrimination angle earlier, and really the bigger angle is the viability of the PESA registered enterprises, because if they can only operate within the zone, and the employees would like to look for a job that allows them to work from home, then these PESA enterprises would need to fight for those kinds of resources by deregistering from PESA. Again, this is what I call the accelerated sunset, which the law could not have intended. It will result to an accelerated sunset because you're not fighting for incentives anymore. You're fighting for viability. You're fighting for resources. And why would they allow you to be put in that situation when we need to be competitive at many things? When it's still part of the SIPP, you know, when you are when they can easily make a solution by just implementing fairness that applies for BOI registered companies and PESA registered companies alike.
Okay. Thank you, Alex. I actually have more points to pursue along that line, but we also have DOLE-related questions. And again, this is still work from home related, Poly. So knowing and recognizing that work from home is a huge benefit to our BPO workers, and there are many of us, there's 1.4 million of us sort of clamoring for that. Is there any plans from the DOLE how you can help the industry, knowing that there seems to be now a limitation to the current version of the Telecommuting Act? How do you think this can be enforced? And if it really has more teeth than what we now think, that CREATE cannot sort of stop us from following the Telecommuting Act. How can DOLE help us be able to, advocate more for the implementation of Telecommuting Act in a bigger scale and specifically for the BPO industry?
For that, actually, the Telecommuting Act only institutionalizes telecommuting as a work arrangement, no more, no less. So with respect to the present issue with FIRB, I think it's best to request for like a consultation with your other stakeholders, that where DOF will be also present to address your issue. Unfortunately, for the DOLE, we have not issued any position yet on the matter, except for one opinion we have shared with ECHO.
Okay, so in that case, I have not heard or read a position coming from the DOLE about asserting the Telecommuting Act. Is that something that the DOLE can, immediately do with the current secretary of DOLE making such statement, considering also that there's a lot of news that has already come out discussing the problems of the BPO industry because of this?
With that, we actually only issued one opinion, and this was addressed to ECHO, where we recognize the authority of other government agencies exercising special jurisdiction over these economic zones. And we have also reiterated there the opinion of the Department of Finance that though these establishments may continue to implement their telecommuting work arrangement, but they may risk of losing their tax incentive if they are required to have their workers return on site.
Attorney Mike, can you say something about that? It seems like if the DOLE itself has mentioned that, applying the Telecommuting Act might result to losing your incentive. So is Telecommuting Act really a recourse for us?
I'd like to look at it differently, Celeste. No? I probably would take off from that statement of Ms. Polly, not to maybe criticize any government agency. I always take the position that each government agency has their own set of deliverables, and they're doing as best as they could what their mandate is under the law. Having said that, however, one thing that we must make sure that government stakeholders realize, and when I say government stakeholders, it always has to be the entirety of the whole, I guess maybe composition of the government of the Republic, is that we're getting left behind. It's not a phrase that's uncommonly used. When we look at our competitors within the space, and we need not go any farther. I mean, within the Asia Pacific region, for instance, we have countries that are actually incentivizing and encouraging this kind of a work arrangement. And where is that push coming from? Precisely, that push is coming from because they're looking at it from a 360-degree view, right? So it's not being looked at from a fiscal perspective solely, but it's being looked at from an employee engagement perspective. It's being looked at from an environmental perspective, right? And it's being looked at from an economic perspective. And once they determine that all of this, there's no decision that will satisfy. Because as you pull one lever, there's going to be one that will have to be sacrificed. No? Not probably 100%, but to a certain extent. So the government has to make that decision. So, for the longest time, the elephant in the room was that if the BPO industry was the one that was whispering on the left ear of the government, asking that the work at home be kept whole in terms of the incentive from a work at home perspective, what other industries were asking, the exact opposite, no? And I guess we saw it already when some of the industries that we anyway partner with, no, came out and said that we've been suffering for quite some time already. Then we therefore need to pull people back into the workplaces so that they can begin consuming the goods and services that are located in the work areas that they're operating in. I think that's probably one area that we should also explore. So I'm not saying that we give up on government, but we also try to look at all the other private stakeholders and maybe make them realize, as we tried to do, Celeste, no, that as and when the BPO industry grows, then the multiplier effect, which could be anywhere from 2.5 to 4, no, depending on who you're talking to, right, will also correspondingly make all these other collateral industries grow. And I think that's going to make the other government agencies realize that they cannot just defer to the FIRB or the DOF because to a large extent, to allow this to happen is going to increase employment. And of course, that's going to be where the Department of Labor is going to come in, right? They don't want to take a position that's going to be averse to the ability to actually increase employment. So I guess that's what I'm saying. I mean, it's many moving pieces, no, between private and public, no. But then it's not insurmountable. And I'll end with what I began with, no. If other countries immediately saw, right, that the wisdom and the viability of allowing this, right? So why can't we? No, what makes us different? And none of their economies actually submerged, right? So there must be something there, and it's really just incumbent upon us to make government realize what it is that they're not seeing or not maybe seeing 100% yet.
Yep. Thank you, Mike. And I guess we really don't stop pushing the boundaries of what we can achieve from this administration, and we are hopeful for a more sympathetic next administration and pursue all of these discussions. But maybe just a last word on DOLE's use of telecommuting. If there is a group in the DOLE that can help us make the current version of the telecommuting act more useful, that it can have more teeth, please let us know who we can talk to so that we won't wait anymore for the amendment of the Telecommuting Act before it becomes useful and relevant to a bigger part of the workforce that really needs it now. So Polly will reach out to you and whoever else in your department you think we can work on the details before we discuss with Secretary Bello or the other officers of DOLE this matter. Okay. There are many questions about penalty. So Alex, we're in a situation that the FIRB's directive is how should I say it? We are scared of what the FIRB can do, and even more scared probably of what the BIR and the BOC are doing to implement the direction or the directive of the FIRB. So you know that for BIR, if we are not 100% back to office, the penalty is losing our incentive for the month that we violated. And there are many questions about that. So it's losing your income tax incentive for the month that you have violated. And for the BOC, it is paying the taxes or taxes and duties for the equipment that have not been brought into the site after March 31. So these are the general consequences of a violation. So with what you are saying, Alex, that there are provisions that should be met before an enterprise or a company should be penalized. Do we have basis to push back when a BIR auditor comes, or when a customs commission, not customs commissioner, collector assesses, taxes that we need to pay? Hindi ba kami nila ipe-penalize lalo at hindi ba nila kami isasara? Sabi mo hindi, but if you can give deeper context so that our audience have a takeaway on what they can do when these BIR auditors come, and many have already visited our premises. So we're still in this situation, Alex.
Yes, yes, Celeste, thank you for that question. Well, number one, when the BIR auditor comes, you must be respectful, you must be accommodating, and insofar as these are very basic requests, you can give in to those requests. So far, ang mga nakita natin na mga nire-request nila, payroll records, and I think parang parang time records ng mga employees, yung mga in and out. So you see, they can't really see anything from there unless they match it with the names of the employees currently within the payroll of the company. So they cannot be computing payrolls. Pero ang pinakamaganda sana when the BIR comes, you entertain them, you sit them down, and if you have someone like Mike Montero, like your lawyer, dapat sit down with them and then explain to them, where you're coming from. In fact, bring up these rules that I mentioned. Hindi tama or walang legal basis yung you're not entitled to incentives during the month that you don't comply. Maling-mali po yan, kasi kahit na 309 po yung gamitin nating basis, only that part which is not conducted within the zone will not be entitled to incentives. Ang ginagawa nila, allocation over a 12-month period.
Right.
You don't even need that kind of allocation kasi if you're talking about the month, may days naman yan. But anyway, what I'm saying is that that's not the right way to go. And they cannot say, this is what you have to pay up. Hindi, may process yan. Meron siyang, they can assess, you can protest, you can reply, this will go to court, most likely, but we have to test it in court. Kasi I think if there's one resounding message dito, and you can sense that as well with the way Mike frames his arguments directionally. These penalties will be upon those who are agreeable. Pag agreeable ka, mapipenalize ka talaga. Pag agreeable ka, makakapag-implement talaga sila ng mga rules kahit walang basis in law. But if you don't tire in pushing back, you avail of your remedies, especially if you avail of your remedies as an industry, the bundle of sticks concept, right? Bundle of sticks will be unbreakable versus the singular protest or the singular sticks. If you act like a bundle of sticks and bring this to the attention of all the government relevant government stakeholders, the DOLE, the BAR, and the IPAs, the Department of Finance and the Department of Trade and Industry, and ask them really, what do you want to do with us? I mean, during the times that when we were recovering, when we were the sick man of Asia, you know, the BPO and the contact centers, they did not perform menial things. I mean, it literally gave our economy, you know, the much needed lift for its head to be above water. And it's not only the industry, it's also the supporting industry, the entire ecosystem that it lifted. Even the real estate industry that Mike was alluding to. If they're not too protective and the 30% outside or the 50% outside grows, if it grows, then the volume will still be there. And then what do you call the industrial zones? Are they not real estate as well? And if the employees are in their houses, I guess the rest of the MSMEs and the retail industry that's available to the area where the employees reside, they're also brought into the fold of economic activity. I
Right.
mean, it's just wrong to look at it as a pizza pie only residing in the zone. It's a pie that resides nationally, even geographically on a national basis. And I guess yun yung talagang message dito. We should just not give up, pushing back, citing legal basis, and always putting our position on an industry level. We should be holding press conferences for this, you know,
Okay.
and complain about all this. I would even call it harassment, because anything without legal basis is harassment.
It's harassment.
Yeah, alam niyo naman yung ginawa nung BAR, and they withdrew. You know, this
Yeah.
the closure of this big company na yung
Right. Right.
nila. You know, because they are in that kind of mode. They're using this shortcut methods, even in things that they should not be using them on. Operation Candado is for those which are not registered and those that don't have receipts. Gagamitin nila kahit sa isang assessment, hindi nagkasundo sa isang issue. Mali, hindi kami nag-aano siya, o plan kandado ka namin. Tama ba naman yun? So magagawa lang yun, kung payag tayo. Hindi tayo papayag, lalaban tayo. Di ba?
Correct. So, and that's the reason why we are holding this session, so that we have like an industry position, and we will be stronger than the bundle of six, I guess. So Mike, yung pushing back, we discussed in our LegCom, nandun din si Alex, and there were three of you who shared your experiences with the BIR audit. And if you can, briefly share that here again, because many probably of those who are here were not in our LegCom meeting, so that they are guided as to what they can do when these inspectors come. The pushback, I think we should agree, we should not pay, but in terms of how to entertain them, how to sort of discuss with them and push back on the documents that they are asking for, I think these are the types of tips that our participants will find useful. So Mike, if you can do that, please.
Yeah, so maybe just some really quick points. One is that I will just echo what Alex said. No? Be respectful, be accommodating, no? Because we're not gonna get anywhere if we just fend them off. We be very defensive, not even know what they're going to ask for. No, maybe as a sub point to that, I've heard so many questions around, and I guess we're seeing a lot of news items in social media that there are suspensions on audit investigations that are happening. And that was as a consequence of all the special audits that were being conducted against some other industries or some other specific companies. No? And we've clarified that with the BIR. We are not included in the suspension. No? So to say that we read somewhere that all the audits and all the spot checks of the BIR has been suspended, therefore you're not allowed the entry or not. We're not going to talk to you. Really, it's just going to put us and run the risk of again earning the ire of the BIR. No? Also, I guess maybe the other thing is that what are they asking for? No, so that we heard from, and it was a smaller group that we heard speak about, the things that the BIR was asking them to submit. No, the two guiding principles that we use, at least as a company, is number one is that if we made submissions already to other government agencies and it nevertheless captures the data points that are being asked by the BIR, even if it's couched in a different format, then in our minds that should suffice already. No? Because at the time that we were submitting them, we were complying with legal directives, primarily of the IPA that has primary jurisdiction over us. No? So we have to make BIR realize that we've submitted this. If you're asking for headcount, the split between work at home and work on site, we've submitted it to PESA, and therefore this is what we'll be submitting to you as well. The other thing also is that we also have to be, again, wary of maybe breaching some of the other regulatory measures that we need to contend with. So if they ask names of people that are working at home versus those that are working on site, is that something that's within the bounds of our data privacy rules, no? Both internal and external. No? Also, they could be asking some, the ability to actually be visiting the floors where we operate in, so that they can do an ocular of how many people are actually there, how many warm bodies they will see at a certain point in time. No? Apart from the fact that from a practical perspective, since most of us largely operate on a night shift basis, and the default is that they will not be seeing a good number of people on the floor when they do the floor walks, is also, of course, the contractual limitations that we operate with. That we cannot just let people that are not sanctioned with the underlying client permissions. But don't say that you're not allowed to use time. You have to. Typically, what we say is that give us a few days so that we can work with clients so that we can get the permission. No? The last point that I want to make, and this is really just dovetailing from what Alex mentioned. No? So now that we have all this aggregation of all the points that we have, no? Both from a business perspective, from a legal perspective, one thing that we probably still lack a little bit of is really the ability to take all these steps in a consolidated manner. So sometimes you will hear that the majority of the people or the majority of the members in an industry or association will take a certain position. No? And then when you bring that position to the regulators, they will come to you and reply that, you can't say that anymore because some of your other co-members did not take that position. And in fact, they had already paid the penalty or they had already accepted our position. No? And that's always a big blow to our efforts. No? So we're not saying that we have to fight the BIR. No? I guess maybe you have officers in your respective associations. HIMAP has a very good lineup of officers. Approach them and ask them what's the latest on this. No? So that as and when the regulators come in, the BIR come in, BIR officers come in, you'd be armed with all the things that other companies have submitted so that they can lawfully defend their position. So as opposed to just giving in and saying that, okay, we surrender. No? So otherwise, masasayang naman yung efforts natin.
Yes, I totally agree. So, related to inspection, siguro this is our last question already. We have overshot our time limit and we would like to be respectful of the time of our participants. But for Dole, you mentioned, Polly, that during the labor inspections, there are reports or information that are requested, and among those that you have sort of listed are details on employees, schedules, and all that. There's a part of the industry that says that if there are inspectors who ask for this, we can say that this need not be provided because it can be a violation of data privacy rights of the employees. I'd like to ask your opinion about that, and maybe Mike, if you have something to say about that later also. So Polly, do you have a comment on that?
Yeah, for the documents that will be required during inspection, there are actually specific documents that the labor inspector will look into. So we have the administrative reports such as the the registration of the establishment under Rule 1020. We also have the OSH program, their compliance 13th month pay, their submission of RTS Part 5 of 2020, should there be any termination or retirement or adoption of any flexible work arrangement. But with respect to a document that would infringe on the personal information of an individual, I think it could still be within the authority of the labor inspector if this is relevant to the conduct of the inspection itself, such as the names, the birthday of the let's say of the employee that must be provided for in the compliance report on 13th month pay or on the adoption of a flexible work arrangement. I think there's a portion there where you have to enumerate the names of the affected employees who will be separated from employment or those who already retired.
Okay, my comment.
No, I agree. I guess maybe what Polly mentioned is that on the one hand, you do have as an exception to the processing of personal information or even sensitive personal information if it's pursuant to any government mandated order, no. But on the other hand, and I think this is what Polly was alluding to, no, we still have to observe the fundamental principle of proportionality. So again, if they're asking about how many people are on a work at home basis, asking for their social security number is not really relevant. No? So then you have to make that you have to make that delineation. No? And I think the respective companies should respectfully bring that up to any government agency. No? But I think by and large they're already aware. They are aware, no, of all these rules that we need to contend with. No? But for the companies, just make sure that you're not unduly sharing all personal information, because there's still that obligation for us to, observe the sanctity of the personal information of our employees as controllers.
Okay, thank you. I think that would be the last of our questions. We're going to close this panel discussion by asking each of you for very short words to close what you would like to convey this afternoon to our members. Your key point. So,
I'll start maybe last info.
Sige Mike, nakasmile ka dyan. You may go ahead.
Mabilis lang naman. Ano, I share your view that what Alex has mentioned is really very encouraging. No? I guess maybe both in terms of just loading the content of the arguments, no, a lot more than what we've come back with to the stakeholders for quite some time now, as well as also the optimism, no, that he has and that I think also share, no, with respect to the personalities that are coming in to take over the very key and critical positions in government. No? But let me just reiterate, no, the risk of sounding like a broken record, no, that the companies really just have to make sure that you're closely monitoring the effects of all these things, no, to our business. Because again, the legal angle is something that Alex and all the legal luminaries can take care of. No? But if at the end of the day, we want the DTI secretary, for instance, to champion our cause, it has to be from a business perspective. And always the question is, if you want something and you're not going to get it, what are you going to lose if you don't get it? No? And we just can't say that, well, we're going to lose something, no? Because that's never going to work. Because otherwise, then they'll just say that, we're working on our own set of numbers and we believe that. And if you don't have anything to counter that with, then we're sorry. We'll just hold our ground. So let's make sure that we're monitoring it and that we're ready to share to the larger group so that the larger group can bring in a more forceful argument. Thank you, Celeste, and thank you, HIMAP.
Thank you. Alex?
Yeah. Well, Celeste, briefly, yung bundle of sticks. If there's a takeaway, I think that will be the takeaway that I think will be very important. Solidarity, one mind, one heart, one voice. And without that, they can pick us up one by one. So I guess if there's that, then the rest can follow.
Thank you, Alex. We'll make you an honorary member of all of our associations within the industry. Thank you. Thank you for that, for your support. Polly, for our employees, please.
Thank you, HIMAP, for inviting us. And with respect to your request earlier, actually, you can tap on the Bureau of Labor Relations and also have table it as one of their agenda for a tripartite executive committee meeting, and perhaps we can bring it to the secretary. So that's all. Thank you.
Thank you. Thank you. Thank you, everyone. This has been a really rich and informative discussion, and I hope that many of you have a lot of takeaways, and you can implement this in the workplace when you go back there. So with that, good afternoon, and see you again. I turn you over back to Cherry, I think.
Yes, thank you very much. Celeste, we are grateful to you for facilitating a very engaging panel discussion. And of course, we are very grateful to all our guests, our speaker, our panelists. And this time, we will call our president of HIMAP, Mr. Vincent Remo, for the closing remarks. Sir Vince.
Yes, hello, good afternoon. I hope you can hear me. It's raining hard in my place. But again, well, we overshot the time by almost 30 minutes, but I guess it's worth it. This has been a very insightful discussion, and we thank our speakers and panelists, Attorney Alex Cabrera, Ms. Polly Ong, of course, Attorney Mike Montero, and of course, Celeste from IBPAP, for facilitating all of this. Our membership committee who headed this session had two things in mind when we started this one or conceptualized this topic for today's session. One is we want to help the members and the attendees here to address the key concerns, and it's a common issue that we are facing. Most of the companies are facing right now in terms of the telecommuting as well as for the tax and the tax implications of what we're doing working from home. And the second is we want everybody to be on the same page, our members as well as all the companies, all the attendees here to be on the same page, so that as one industry together with IBPAP, we would have one voice as an industry, so that we can move forward by simply stating what we think is best for the industry, for the interest of our economy, and of course, for the overall progress of the country. So again, thank you very much for attending today's session. This is one of the most attended sessions. We reached 200 at a certain point in time, and we still have over 100 right now. So I guess we have already benefited from this session, and we hope that if we have some more questions, Celeste and the rest of the team, we would be accommodated to further this discussion. There could be a part 2 if necessary. And for those who attended today, finally, we are actually making this available. The recording of this is being made available by our secretariat in our YouTube channel. So you can always refer to that one as well. Okay, once again, thank you very much, and have a great weekend, everyone. Thank you, and bye. Bye-bye.
Thank you.
Thank you, everyone.
Thank you.
Goodbye, Miss Judy. Thank you. Hello.
Yes, thank you, everyone. Thank you for joining us. See you again next week
Yes.
for our next session.
Thank you, Judy.
Thank you. Thank you to all the participants.
Thank you, Miss Gail.
Okay, thank
Sir
you.
Vince. Yes.
Thank you, everyone. Bye.
Thank you,
Thank you.
Celeste.
Bye.
Thank you, Ms. Polly. Thank you, Attorney Cabrera and
Salamat,
Attorney Mike.
salamat.
Salamat
Great
po ng
session.
marami.
This has been a great
Thank
session.
you.
Great.